Trial resumed. Jury not present.
The court said, "Note your appearances, please."
Mr. Finkel said, "Ryan Finkel and Justin Horton for the government. We'll be joined by the rest of the team shortly."
Ms. Schrofa said, "Good morning, Your Honor. On behalf of Mr. Gua, Sabrina Schroff, and Scott Skirrick, Mr. Kamraju will be here shortly."
The court said, "Is there anything you'd like to bring up before we start?"
Mr. Finkel said, "Your Honor, the government has a few issues. I think I'll start first with the victim who is on the stand right now. First, just at the outset, the direct of that victim was approximately an hour and 10 minutes. I think the cross has so far been about 50 minutes just in terms of what is left for today. But to get to the heart of the issue, last night about 11 o'clock or so, the defense produced an exhibit to us marked DX 7016. Can I provide a copy to the court?"
The court said, "Go ahead."
Mr. Finkel said, "This appears to be the victim's resume, and a link to a profile that she is online. There is a very superficial redaction of that profile. There are a number of reasons I can think about why such an exhibit is improper. The first is relevance. Maybe that's the simplest way to deal with it. I can't understand how a victim's resume is in any way relevant to whether or not she was defrauded by Miles Gua. To the extent they're trying to show that she was an auditor or involved in risk management. Those issues were covered, asked and answered many times yesterday, so that's number one. Number two, Your Honor. If she is a victim, and I think that this resume, especially in context of what other exhibits were introduced yesterday, and the line of questioning against this victim, which from the government's perspective is just designed to harass her, violates her rights under the Crime Victims' Rights Act. And, Your Honor, there are, of course, confrontation clause issues that arise when a victim takes the stand. But citing United States v. Bannister, this is 2023 WL 259-6890. It's a Judge Engelmayer opinion. The Crime Victim Rights Act requires district courts to implement procedures to ensure that crime victims are accorded, among other rights, the right to be reasonably protected from the accused, and the right to be treated with fairness and with respect for the victim's dignity and privacy. Judge Engelmayer goes on to explain that, while the Confrontation Clause of the Sixth Amendment guarantees defendants the right to confront government witnesses testifying against them, it is not absolute. Citing a Supreme Court case, California v. Green, a defendant's rights under the Confrontation Clause must yield to accommodate other legitimate interest. Citing a Second Circuit case and a Supreme Court case. For instance, trial courts have wide latitude to impose reasonable limits on cross-examination based on concerns about, among other things, harassment, prejudice, or witnesses' safety, quoting a Second Circuit case, and quoting Federal Rule of Evidence 611b. If the government, according to Judge Engelmayer, provides a reason to limit disclosure of identifying information in open court, the defendant must demonstrate a particularized need for such disclosure. That case, Your Honor, was in the context of a VUSR in which Judge Engelmayer sealed from the public record a victim's identity and replaced it with initials. But Judge Engelmayer, in this opinion, and I have a copy for Your Honor if you like it, cites to criminal cases, including U.S. v. Maxwell and other criminal cases where pseudonyms were used. We're not using a pseudonym here, but nonetheless the Crime Victim Rights Act does protect victims from harassment and prejudice. But more to the point, Your Honor, there is no proper purpose to introduce this victim's resume to make her a target of harassment and attacks online or in other ways. And so, because it's irrelevant, because it was asked and answered, and her history was covered yesterday, and because of the Crimes Victims' Rights Act, this exhibit should be excluded.
The court said, "Ms. Schroff, What would the resume accomplish that you have not already accomplished by your detailed questioning of her concerning her credentials and her work history?
Ms. Strofa said, Your Honor, we don't need to introduce the resume into evidence. We provided it to the government because the witness testified that she did not take an accounting class, and she did not have accounting lessons while she was an undergraduate student in China. I was considering crossing her with it and using it for impeachment purposes. So in an abundance of caution, we sent it to the government. There would be no scenario under which I would disregard the court's ruling and introduce into evidence somebody's address. So that's not where we're going. Thank you.
The court said, so essentially you expect to be asking here, isn't it true you took an accounting class in this year?
Ms. Strofa said, that was it. I wasn't even sure I was going to do it, but we decided to go ahead and send it anyway. The document is public. We only found the document on the internet. It's still up.
The court said, my question for you is, do you intend to use it today to try to refresh her recollection?
Ms. Strofa said, no, to impeach her possibly, because she in fact said, I did not take an accounting class.
The court said, right.
Ms. Strofa said, that's the only reason I would ask.
The court said, I'm trying to understand what your question would be. Is it, didn't you upload to the internet a resume stating that you had taken accounting? Is that the question?
Ms. Strofa said, no, Your Honor. What I was going to say is, yesterday you testified you did not take accounting classes. Correct? Let me show you document marked as X. Isn't it a fact in your resume you stated otherwise? And point her to the thing and that would be that. It's just pure impeachment. I'm not seeking to introduce the document. I'm not really sure I'm going to do it. It was just a thought.
The court said, Mr. Finkel.
Ms. Strofa said, only because it's relevant under Litvack it was a thought I had. And again, nobody is seeking to introduce any unredacted documents or do anything untoward here. Obviously it's just, I don't know exactly what happened why we didn't send it to them redacted. It's been a long night.
The court said, all righty. If it is her plan, Ms. Schroff's plan to state as she just said. Yesterday you said you didn't take an accounting class. Isn't it true that on your resume you stated that you did take an accounting class? That's pure impeachment. It's not for the purpose of actually admitting the resume. I don't see what would be objectionable about that.
Mr. Finkel said, Your Honor, I'll have to check the transcript on that. Candidly, Your Honor, I disagree with what Ms. Schroff is saying that this is all for proper purposes and not designed for improper purposes. The government's perspective, Your Honor, is that Ms. Schroff is crossing this witness to embarrass her and harass her. Yesterday she told Your Honor that she was putting those IDs into evidence because they were going to be chats introduced. There were no chats. She just wanted to blow up who this person was online, and I don't think that's appropriate.
The court said, so she has to have the opportunity to confront the witness. It simply would be improper for me to deny her the opportunity to try to impeach the witness, so I will permit her to ask the question that I just posed in the form that I posed. It ends there.
Mr. Finkel said, I appreciate that, Your Honor, and I completely understand. And the government's point of view is yes. She's allowed to cross-examine about a witness's credibility. I agree. The government agrees. We would just ask in light of what had happened yesterday, and I'm sure I'll object that Ms. Schroff not harass the witness. That's all. And I think that our position on that is clear, and I understand the court's ruling.
The court said, well, vigorous cross-examination sometimes involves making a witness feel uncomfortable, and that simply is a reality of criminal litigation.
Mr. Finkel said, I understand.
The court said, there is a border of course between vigorous confrontation and crossing over into harassment or badgering. I have not seen harassment or badgering of this witness, and so I'm confident that Ms. Schroff will not go there.
Ms. Strofa said, thank you, Your Honor. I will be happy to show the government when the moment comes the use of the IV handle and the chats.
The court said, what is the second issue?
Mr. Finkel said, the second issue, Your Honor. And we raised this because we had a number of back and forth with the defense via email just trying to get a straightforward answer to two straightforward questions that has not been provided. The defense is going to call Maggie Sklar, who is their cryptocurrency expert. We've asked them whether Ms. Sklar intends to testify about her review of the blockchain or her review of smart contracts. It's frankly a yes or no question. If the answer is yes, we're going to file a letter on this issue because we believe it's beyond the scope of her disclosure. And we'll brief that, but we don't want to waste the court's time and file a letter needlessly. We asked that question I think 3 times. We've got circular responses. I would ask the defense to please inform the government whether Mr. Sklar intends to testify about her review of the smart contracts and the blockchain for HCN and HEO.
The court said, Ms. Schroff or Mr. Skirek?
Mr. Skirek said, Your Honor, we did indeed have a back and forth with the government on this issue. We referred the government repeatedly to Ms. Sklar's expert disclosures. In particular referred the government specifically to our April 29 disclosure. And even more specifically to Section 22 of that disclosure, which says in relevant part, and I'm quoting, Ms. Sklar will further opine that given HCN and HDO each were minted using smart contracts which can be seen on the public Ethereum blockchain, and are purchased using fiat currency and traded, they meet the common market understanding of cryptocurrency. So the 2 questions Mr. Finkel posed are answered by the particular disclosures and the other disclosures that contextualize that statement.
The court said, Make it easy for me. What are the answers? He's asking you a very straightforward question. I want to hear your answer.
Mr. Skirek said, The question, Your Honor, is will she testify about having reviewed the smart contracts? The answer is, she may testify about that, yes, that's within her disclosure. And that she reviewed the smart contracts on the publicly available Ethereum blockchain.
Mr. Finkel said, the answer is yes. And we would have appreciated just getting that straightforward answer via email instead of wasting the court's time this morning. We'll respond with a letter so the court can resolve the dispute. While we're on the topic of experts and defense case in general, we requested last night the defense provide what the government has provided, which is a list of the exhibits they intend to introduce via each witness. We have not received that. They might have a witness today, Mr. Duran testify. We don't know what exhibits, if any, Mr. Dragon testify. We don't know what exhibits, if any, they're going to introduce. And we ask the defense be held to the same standard the government was held so that the trial is efficient during the defense case, including that they provide any draft slides of work product, which would be 26.2 material, since it's prior statements of the witness, which we haven't received either. We have no summaries. We have no demonstratives. Their 26.2 material talks about demonstrative exhibits. We haven't seen them. We might have objections to them. We might not. We might be able to talk to the defense and resolve these issues without involving Your Honor or the jury's time. It would be appropriate for them to provide this to the government. We ask the court to order them to do so.
Mr. Skirek said, Your Honor, to the extent that the defense plans to introduce any documents that are not already in evidence, we will provide that disclosure to the government.
The court said, I'm sorry, Mr. Skirek, I did not completely hear what you said.
Mr. Skirek said, I said to the extent we plan to introduce any documents through the expert testimony that are not already in evidence, we will of course provide the disclosure to the government.
The court said, they're asking to know specifically what you intend to introduce, not to hear that there's a body of evidence that pertains to a particular witness.
Mr. Skirek said, maybe I misunderstood, Your Honor. I thought the question was whether we plan to introduce any new documents. I thought Mr. Finkel was referring to a demonstrative that we may use with the experts. Not documents that are already in evidence, but perhaps I misunderstood.
The court said, my understanding, and if I'm wrong, correct me, please, is that they want to know what exhibits correlate to each witness that you're going to call. Am I correct?
Mr. Finkel said, yes, Your Honor. And in particular, any new exhibits they intend to introduce, and the demonstratives. The demonstratives, it says 26.2 material, in effect reviewed demonstrative or demonstrative exhibits. We don't have those. If they're going to put it in front of the jury, even the demonstrative, they should give to the government.
Mr. Skirek said, "Of course, Your Honor. We understood that. And that's what I understood Mr. Finkel's point to be, was demonstrative or new exhibits. And of course we will provide that. No decisions have been made with respect to the use of demonstratives that would require us to produce them at this point."
Mr. Finkel said, "Just so Your Honor knows, one of their experts may testify today. We have not received the demonstratives. We don't know if they're introducing any exhibits. If the answer is no new exhibits will be introduced through this witness, then just tell us. Then we know, and we could be more efficient with Your Honor's time and the jury's time. If the answer is maybe, then give us the universe. We've done that. We've said, here's a body of 30 or so exhibits or more sometimes. It will be a subset of that. They haven't done that. And frankly, Your Honor, we're at a point in this trial where efficiency should be the rule of the day, not tactics and delay and circular answers."
Mr. Skirek said, "Your Honor, if I just may briefly. First of all, there are no new exhibits. There's no demonstrative that we plan to use with Mr. Dragon. Obviously we have continued to work with the experts who are going to be among the first defense witnesses to testify. And we didn't want to preclude ourselves from potentially, as of yesterday, being able to use something should we want to, so we hadn't made any disclosures to the government. I'm frankly just not sure what the issue is. Of course we know our obligations and of course we will disclose them. And we have no intention of using a new exhibit or a demonstrative with Mr. Dragon."
The court said, "All right. Now we know there's nothing new and no demonstratives."
Mr. Finkel said, "And that's helpful. And Your Honor, just moving forward since they have 11 witnesses or so, we would appreciate the defense works the other way, which is, instead of saying, we don't know what we're going to introduce, so we're not going to tell you anything. Tell us what the government has done, which is, here is the subset of exhibits that we might introduce. And if it turns out they're not going to, that's fine, that would make things more efficient. That's what the government has done. We also would request, and I think they should provide us some information as to the compensation for these experts. That's the government's request."
Mr. Skirek said, "Your Honor, with respect to the compensation disclosure. That's obviously a standard question that the government is going to ask the witnesses on cross-examination, which the witnesses will answer candidly. The government only raised this issue with us, I believe, in the minutes before we walked into court this morning asking for some disclosure pre-testimony. We're happy to entertain that. But the parties haven't had a chance to discuss that yet, and Mr. Finkel is raising this now for the first time with the court. So we're happy to discuss that with counsel and arrive at a mutually agreeable way to go about that."
Mr. Finkel said, "We appreciate that."
The court said, "In a word, this trial for me has been unprecedented, and I am hoping that as we move towards the finish line that the attorneys will show a greater degree of cooperation with each other. Alrighty, we'll start at 9:30.
Continued on next page.
The court said, "Counsel, I'd like to remind you that the interpreters would like you to slow down, especially if you're reading from a document. Have the jurors come in, please."
The law clerk said, "Jury entering."
Jury present.
The court said, "Please be seated. Good morning, jurors. We're going to continue with the cross-examination of the witness. Ma'am, remember that you're still under oath. You may inquire."
Ms. Schrofa said, "Thank you, Your Honor."
Wei Chen. Cross-examination continued. By Ms. Schrofa.
Good morning, Ms. Chen.
Good morning.
Ms. Chen, you testified on direct about GEV, correct?
Yes.
And you testified that you heard Mr. Gua say that the GEV business had a bright future ahead of it, correct?
Yes.
And you testified that you watched a video where he said that GEV was going to have a very powerful platform, correct?
Yes.
And you said on direct testimony that you heard Mr. Gwa say that he anticipated GV would be successful, correct?
Yes.
And that was going to be very powerful, correct?
That is going to be very valuable.
I'm sorry.
That it is going to be very valuable.
That it was going to be very valuable. Thank you. And you also understood Mr. Gwa to say that he would be working towards acquiring software for the platform, correct?
Yes.
And that he would do all he could to make it a strong software platform, correct?
Can you repeat that question again?
Sure. And you testified that you heard him say that he would make it a good platform with good software, correct?
Make a good platform with a good software?
Right. He would have people working on the software behind the platform, correct?
He would have the technology infrastructure to build the platform.
Right. So you heard him say he would get the technology infrastructure to build the platform, right?
That's my understanding.
Okay. And when you say that is your understanding, what exactly is it that you mean?
That means I heard him saying that, and I take away that's a messaging conveyed to me.
And that was your understanding back then, correct?
Back in the time when I heard it and decide to make the investment.
And sitting here today, do you by any chance know if there was any undertaking of a technological infrastructure?
Can you repeat the question again?
Sure. Do you know sitting here today whether Mr. Gwa or anyone at GV took such steps? Do you know?
Such steps, what do you mean by that?
Do you know if anyone at GV was working towards making it a good platform?
I'm not sure.
Now, you also testified that you were influenced by Mr. Gwa's claims of wealth, correct?
I testified that I was influenced by him portraying as a very wealthy person.
Let me ask you a follow-up question. When you say portraying as, what did you say very?
Wealthy person.
Wealthy person, right?
Yes.
And did you know if in fact at that time he was wealthy?
From what he said at the video, I thought he was very wealthy.
My question was whether you independently knew him to be wealthy.
Mr. Finkel said, asked and answered.
The court said, sustained.
Did you do any research into his wealth?
Mr. Finkel said, Your Honor, this is with respect to the court's ruling discussed after court yesterday. Objection.
The court said, sustained.
What day did the PPM close?
PPM?
The private placement, when did it close?
I made the investment till I believe June 2nd, 2020. And if I remember clearly or correctly, there might be a day off from whichever June 2nd is. Don't quote me on exact June 2nd, but around that time. That was my recollection.
Your recollection is it was June 2nd, not June 26th.
It would not be that far, beginning of June.
Let me show you what is marked as Defense Exhibit 7015. And if I could just make sure it's just shown to the government, the court, and the witness. Do you recognize that? Ms. Chen?
Yes.
What is it?
It is a video with Miles Gwa claiming bankruptcy.
Ms. Shrofa said, Your Honor, we moved DX 7015 into evidence.
Mr. Finkel said, One moment, please. Objection. It's the defendant's statements.
Ms. Shrofa said, I'm going to show it for the effect on her state of mind. I don't care if it's true.
Mr. Finkel said, This is February 2022.
The court said, if you'll step up.
Continued on next page. At the sidebar.
The court said, to show the effect on her state of mind?
Ms. Shrofa said, he declares bankruptcy. He does so publicly. She testified that she's influenced in her investments based on his wealth. After he declares personal bankruptcy, she continues to invest. That's it. State of mind, her knowledge that he openly says he's filing personal bankruptcy.
Mr. Finkel said, You can't ask those questions without introducing the video of the defendant's statement.
Ms. Shrofa said, Of course I can, but that doesn't mean that I should or I'm required to. My client is entitled to a robust defense, and this is admissible for the purpose of which I stated.
Mr. Finkel said, Robust defense does not overtake the federal rules of evidence. And the defendant's statements are not admissible by the defendant, and that's the purpose. To the extent there's a dual purpose, which is to say the effect on the listener, the victim, and also the statements of the defense, the defendant, then the court has discretion to decide how to proceed. The government's point of view is that the court should not permit playing a video of the defendant's statements and allow Ms. Schroff to ask the question about what effect, if any, Mr. Gua's declaration of bankruptcy had on her analysis. I would also add that the fact that the defendant declared bankruptcy seems to be suggesting that essentially the victim should have known better, that she should have known that Mr. Gua wasn't really rich, and that from the government's point of view is that it infringes on Your Honor's ruling about the sophistication of victims.
Ms. Schroff said, Your Honor, other than the fact it is admissible, I'm not seeking to go as far as the government is attributing to me. The video is admissible to show how she went through her process. They went through her process. They are the ones who focus repeatedly on his wealth, his wealth, his wealth. I should have some leeway to cross. And the federal rules of evidence in fact does allow for the admittance of the video. And of course you can give a limiting instruction. I have no objection.
Mr. Finkel said, it doesn't allow for the admission of the defendant's statement. That's the government's point of view.
The court said, that's my understanding of the law. I'm not going to permit it. Of course you can question on that issue.
Continued on next page. In open court, jury present. By Ms. Schroff.
Ms. Chen, on February 15th of 2022, you watched a video, correct?
I knew he filed bankruptcy on February 15th, 2022.
My question to you is whether or not you watched a video on February 15th, 2022, where Mr. Miles Gua discussed the fact that he was filing for bankruptcy.
I don't remember if I watched that video specifically you talk about.
So you remember some of the videos where he spoke. You just don't remember all of the videos where he spoke?
It's been such a long time.
2022 is after 2017, correct?
Yes.
After 2018 and 19, correct?
Yes.
And your testimony is you don't remember this particular video, correct?
Mr. Finkel said, asked and answered.
The court said, sustained.
Do you recall Mr. Gua's statements that he was declaring and signing the bankruptcy petition on that very day?
Mr. Finkel said, asked and answered.
The court said, you may answer.
Sorry. Can you repeat that question again?
Sure. Do you recall Mr. Gua saying on the video that he was signing the petition on that day, February 15th of 2022?
So I think I said I did not remember if I watched that video specifically that you are referring to. And also I stated that I knew that Miles Gua filed bankruptcy on February 15th, 2022.
Did you read the bankruptcy petition that he signed?
I do not think so.
I'm sorry.
I don't think so.
Do you know if your husband watched that video?
I don't know.
Now let me move to GXVK5. May I have it brought up for everyone since it's in evidence? You recall testifying about this document, Ms. Chen?
Yes.
And you reviewed this document with Mr. Finkel when you met with him at the United States Attorney's Office, correct?
He showed me this document.
Right. And after he showed you the document, did you two go through it?
I did not go through after he showed me. I just looked at the document when he showed me.
So you only looked at the first page of the document and that was it?
He also went through other pages.
Okay. So he reviewed the document with you, correct?
That's not correct. My understanding of review is review the document entirely. If I understand when you say review, that's the meaning. So I say that's not correct because I did not review this document with him.
So is it fair to say you did not review the entire document with him?
He showed me the document. When you say review, can you clarify what does review include?
You tell me what you think review means?
Mr. Finkel said, I think that was answered already. Objection.
The court said, did you read the document word for word?
The witness said, so her question asked me, did Mr. Finkel review this document with me? So my answer to that is no. He did not review this document word by word to me.
The court said, go ahead.
How about pages by pages?
The answer is no.
How about some pages?
Certain pages, yes.
Did you choose the pages or did he choose the pages?
He showed me. Did you see this page? Just ask. As to the testimony yesterday, he showed me a page and asked me about it, and that's it.
And yesterday, when he was showing you the pages in the courtroom, he had shown you those pages before, right?
Not all of them.
So you remember what pages you reviewed with him because you're now able to tell me not all of them, right?
I don't remember the pages he showed me, but he showed me the page and asked me the information. I think some of the information is not what he reviewed, not what he showed me last time when I met with him.
You met with him more than once?
I met him more than once, yes.
And did he show you this document more than once?
No.
Well, let's see what we can talk about from your testimony yesterday. Yesterday you testified that you did not consider the risk factors in the PPM, correct?
Mr. Finkel said, misstates the testimony.
The court said, sustained.
Let's pull it up. You remember talking about the standard language in this document? You remember the judge asking you what you meant by the phrase standard language? Do you understand that?
The court said, you may answer.
Your question is, do I understand that I testify? Is that your question?
Yes, that is my question in fact.
Yeah, I remember I testify that.
And you remember the court asking you what you meant when you said that those were standard language, correct?
Yes.
And your response said, like in a legal document, it oftentimes would have the language talk about risk. Remember that?
Yes.
And when you said that, had you an understanding of standard language in PPMs in other situations?
Mr. Finkel said, objection.
The court said, overruled. You may answer.
No.
And had you ever compared PPM language?
No.
So when you said that this was standard language in this document, you had no basis of comparison, correct?
Mr. Finkel said, objection, goes to the court's ruling.
The court said, overruled. You may answer.
That's just a way of my expressing how I think those are just certain terms put in a legal document. And I use standard language to explaining my understanding of terms in a legal document.
Right. But you're testifying under oath today, right?
I testify under oath by saying the truth.
Right. And the truth is that you did not ever compare the language in PPMs with each other, correct?
This is the only PPM I have ever seen. I have never had an opportunity to see a PPM because Miles Gwa said this is right opportunity. I have no opportunity to even see a PPM document.
Well, you have access to Google, right?
Everyone have access to Google.
I'm sorry.
Yes.
Let me move on and show you page 29 of the PPM. Okay. Actually, I'm sorry. Page 29 is the last page of the PPM, right? The entire document is 29 pages long, right?
I don't remember. If you say it's 29, it's 29.
It's right there for you to look at.
I don't know. Does that matter if it's 29 pages? If you say it's 29, it's 29.
Okay, let's try and go to page 9. You see that document?
Yes.
And we talked yesterday about the last paragraph, so I won't go back there, okay? But this, just to give you a perspective, and let's go to page 10. You recall being shown this document on your direct testimony?
Yes.
And was this one of the pages that Mr. Finkel and you reviewed in his office?
He showed me this page in his office.
And then he asked you questions about this page, right?
Yes, he did.
And he asked you about the two figures split side by side, right?
No, he did not.
Well, I'm going to ask you some questions about that. Is it fair to say, Ms. Chen, that the figure on the left side shows the ownership structure before the PPM, and the figure on the right side shows the ownership structure after PPM, correct?
From what you're showing here, and you highlight it, yes.
I don't have to highlight it for you if you prefer I not.
The court said, don't testify. Just ask questions.
Ms. Schrofa said, I wanted to make sure I did what the witness wanted, Your Honor. And on both sides of the screen, Ms. Chen, it shows Soraka has an ownership interest in GDV, correct?
Yes.
And on direct, Mr. Finkel also asked you, and we can take that down and move down on the same page about this chart, correct?
Yes.
And he specifically asked you a question about this 5%, right?
Yes.
And he focused you on the word other, correct?
He asked me what my understanding about the other.
And you said that your understanding was that it was some overhead administrative cost, correct?
Yes, I understand it's the HR administrative hiring cost with the people talents.
And that was just your understanding, right?
Yes, because you need talents, the people.
Because of what?
You need the talented people.
You need talented people?
To develop GTV business, that's my understanding of what this other is for. To hiring talented people to grow and develop GTV business.
Okay. But you would have talented people if you acquired companies that had talented people working for them, correct? Like as it says on number 1, acquisition of companies to strengthen and grow GDV. If you acquired a company that had a lot of talent, that talent would also come in under the approximate 70%. Correct?
Mr. Finkel said, objection, form, and calls for speculation.
The court said, sustained.
Is that your understanding?
The court said, sustained. I sustained the objection. You don't need to answer.
What is your understanding of acquisition of companies to strengthen and grow GDV?
My understanding is acquire certain software or technology may have already developed to some extent that you can grow upon it with talent you're hiring for GTV to make it more successful.
And what does acquisition of companies mean to you?
Acquisition of companies that already develop somewhat model of software or technologies that are in place.
To develop that technology, you need people, right?
You would need more than just the people you acquired from that company. If you make a big business successful for GTV to have not just the media platform, but also doing the transaction. You cannot just acquire companies without having your own people managing the business make it successful. That's common business sense.
Thank you, Ms. Chen. Now, if we could go to page 15, please. Do you see that?
Yes.
And you were asked questions about this page as well, correct?
Yes.
You were asked who Mr. Blanton was and Aaron Mitchell was, correct?
I don't think so, but maybe. I don't remember.
And then you see at the bottom it says sponsor and advisor of GTV Media, correct?
Yes.
Could you read the first 2 lines for me?
You talk about the 6.3 sponsor and advisor?
HM.
I think I read it, yes. Do you want me to read it again?
Yes, please. I would really appreciate that. Thank you.
The sponsor and advisor of GTV Media, Mr. Wengue Gua, aka Miles Gua. Hoan Kwok or Miles Kwok is a billionaire, a successful businessman and a dissident in China.
Keep reading.
He knows deeply how the Chinese Communist Party CCP deprives the people of China of human rights, justice, freedom of speech, freedom of press, and freedom of religion. He's dedicated to overthrow the CCP regime, to bring back truth, freedom, and justice to the people of China. Miles Gua is the key host of the GTV Media.
This section, it's fair to say, describes the billionaire as the sponsor and the key host, correct?
That's the word by word in this paragraph.
Thank you, Ms. Chen. You can take that down. Now, when you read this document, did you recall the role that Mr. Bannon was going to play in this venture? Did you focus on Mr. Bannon at all?
I know he was listed as the non-executive director, and then that's it.
Did Mr. Bannon's presence as a woman come as a negative for you to invest in GDV?
Mr. Finkel said, object to the form.
The court said, rephrase that, please.
As a woman, were you offended that Stephen Bannon was going to be part of this project?
Mr. Finkel said, same objection.
The court said, you may answer.
I don't understand this question.
I'll move on. Now, let's go to page 15 of the same document and moving down to 18 to 19. You were asked questions yesterday about the risk factors here, correct?
Yes.
And the document lists the risk factors, correct?
Yes.
The document says that the company has no operating history, correct?
I did not see it. Where do you see that? You ask me when I'm reading this document now, or asking me about the time when I was reading this document when I made the investment?
Well, I was asking you about this document when you read it before you made the investment.
Your question is asking me, did I read the risk factor saying it has no operating history?
Yes, ma'am.
I don't remember I read that part when I made the investment back then.
How about did you read that the company's management has broad discretion in how the company uses the net proceeds of the sale of common stock?
Yes, I remember that 100% exactly.
And could you tell the jury what your understanding is of net proceeds?
My understanding of net proceeds?
Yes, ma'am.
My understanding of net proceeds is you will have sales proceeds or profits that minus the operating cost, and then that equals the net proceed.
And if you included the operating cost, would that be gross proceeds?
If you're including, I don't know.
Well, let's go to page 25. And on page 25, what does it say in bold? The company does not intend. Could you read that?
You are not entitled to receive.
No, just the title.
The company does not intend to pay dividends for the foreseeable future.
And let's go below that where it says, Soraka owns a controlling interest. Read that part at the bottom.
Soraka owns a controlling interest in the company and can exercise significant control over the company.
And that's on page 25 of 29, correct?
It shows on 25 here.
And we can take that down. Now, Ms. Chen, you also testified about receiving stock certificates reflecting your GV shares, correct?
I testified that I was able to log into website to purchase 2 papers.
And you purchased them yourself, or did your husband purchase them?
We log into account together, and I watch him pay for it.
I see. And you talked about that process with Mr. Finkel when you prepared for your testimony here, right? You talked to him about that process, right?
When you say I talk about the process, meaning I talk about the process of going to the website and downloading the paper, is that what you're asking?
Yes.
I think so.
But it was really your husband who went to the website? You were watching, right?
Mr. Finkel said, asked and answered.
The court said, sustained.
Did Mr. Finkel ask you for a copy of the certificate?
No.
Well, let's show you DX60672. Do you recognize that document, Ms. Chen?
Yes.
Ms. Strofa said, Your Honor, the defense would move to admit 60672.
Mr. Finkel said, Are there any other pages in this exhibit? The FBI?
The court said, Are there any additional pages?
Ms. Strofa said, We're showing them to the government now.
Mr. Finkel said, May I inquire one question?
The court said yes.
Mr. Finkel said, Ms. Chen, did you send this document to?
The witness said, I don't remember.
Mr. Finkel said, No objection.
The court said, It is admitted.
Defendant's Exhibit 60672 received in evidence by Ms. Schrofa.
And if we could just publish that to the jury. Ms. Chen, you sent a lot of documents to the FBI, right?
Can you define what is a lot of documents?
You sent a lot of documents?
Mr. Finkel said, asked and answered.
The court said, She asked if you would define what you meant by a lot.
I didn't hear that at all, so I apologize. Did you send more than 50 documents?
I don't think so.
How about 30?
I don't remember if it's I don't count. I sent some documents, yeah.
We can take that down. I'm sorry. I just want to make sure the jury saw all pages. Now, yesterday you also testified, did you not, about the Rule of Law Foundation, correct?
Yes.
You testified that you donated $30,735, correct?
I don't know if I testified that exact number. I just say I donated about $30,000.
You recall sitting here today that was 3 days in a row, September 28th, 29th, and 30th?
So can you repeat? What do you mean the 3 days? Can you clarify your question?
Sure. You first donated $400. That was your husband who did the first donation, correct?
I want to make it clear, when you say my husband did it, we jointly did it. But then he's the one who processed it, so that has his name. So I want to make it very clear as we jointly did it.
Okay.
So you can make it clear in the future, not just always say your husband did it.
Your husband did it. You jointly decided. Is that accurate?
My husband is the one logged in the web. And again, I was there with him, so we did it together. If you can make that clear. You cannot always say my husband did it.
But your husband did in fact did it? He logged in and he paid for it?
The court said, Ms. Schroff, when you use the word did, you need to define for the witness what you meant.
Your husband logged into the website, correct?
Yes.
He used his password, correct?
I don't know if you need a password to do a donation. You mean log in the computer or log into the website?
I mean log into the computer. He logged in, right?
Yes.
And he went through the steps of doing the donation, correct?
He go to the website and he went to website and he's the person process it, yes.
Thank you. And the processing was on September 28th, 29th, and 30th, 3 days in a row, correct?
I think you're mixing up the time. You're talking about donation $400 back in 2020. And you also talk about 2022. You're making it very confusing to me. I don't know what you're asking.
Well, first of all, I'm just going to ask you to slow down because the interpreter is going to have a lot of trouble. And let's see if we can start again. There was a $400 donation in the first instance, correct?
Yes.
What year was that?
I think it's in 2020.
And what year was the $30,000 donation?
2022.
Okay. And the 2022 donation was for $30,000, correct?
Yes.
And that was 3 days in a row. 10, 10, 10, September 28th, September 29th, and September 30th, correct?
I don't remember exactly.
And you thought, and you told the government that you would not have made that investment, as you call it, if you didn't think that you could get your money back from the Rule of Law Foundation. Do you remember that?
Mr. Finkel said, I have a form objection. It's confusing.
The court said, you may answer.
Sorry. I didn't understand your question. How would my investment have anything to do with a donation? I didn't quite understand your question.
Do you recall telling the government that you would never have donated this money if you didn't think the Rule of Law Foundation wouldn't give you the money back?
I never say that. I don't think so.
Let's show you 3,526 at page 2. Do you see it on your screen, ma'am?
I saw it on my screen.
Does that refresh your recollection that you used a credit card to invest $30,735 in Rule of Law? You thought it was an investment. And you would not have made that investment if you did not think you would get the money back?
I don't recall saying that at all. I think it's maybe taken down differently.
Thank you. Let's talk about G Club. Okay, you testified about G Club yesterday. And you testified that it launched in October of 2020. Is that right?
Yes.
And you tell me whether it was you who bought it or your husband who bought it. The G Club membership in October of 2020?
Let me make it clear, we never bought G Club membership.
Ma'am, what year did you sign on for a G Club membership account?
So I think your question asked me is in March 2021, who bought the G Club membership. So what I'm responding to you is, your statement is not correct. We never bought any G Club membership.
You can define it in any way you choose, Ms. Chen. There is something.
Mr. Finkel said, objection to the commentary.
The court said, stick to the questions.
You know something called G Club?
Yes.
Was there something called the G Club membership?
Yes.
What was the G Club membership?
I don't know what is G Club membership.
Well, you gave money to that institution, right?
I gave money to the bank account that is given to me by the MOS farm volunteer.
And for what reason did you give them the money?
To GTV shares, for additional GTV shares acquisition.
And what website did you go to follow through on this transaction?
I follow up with the MOS Farm volunteer, confirming that the money I sent to the bank account be given to me has been received. And then they send me the confirmation confirming that the money has been received.
Right. And you said you got a confirmation that the money had been received by an entity called G Clubs, correct?
The MOS Farm Discord confirmation just said this is amount. It's been received.
And received for what?
Confirm.
What was the company?
You mean the money where I send the money to? What's your question?
That is my question. What company were you purchasing a product from?
I did not purchase any product from any company. I made it loud and clear. I sent the money to purchase additional GTV shares.
Let's show you GXVB24. You testified about this document yesterday, correct?
I testified this is a document with instructions provided to us to complete after we sent the payment to Crane Advisory.
And the document says the purpose is G Club membership, correct?
I did not see that.
Mr. Finkel said, objection.
On the right under the word purpose. I don't want to highlight it for you, but the right column. G Club membership purpose, right?
That's the instruction given. There's no choices.
Well, the choice is to not fill the document out at all, right?
Mr. Finkel said, object to the commentary.
Ms. Schrofa said, it's a question.
The court said, so keep it to the questions, Ms. Schroff.
I can't answer that question because I have already made the payment to Crane Advisory. I have no choices of not signing this document because I already made the payment. So there's no choices for me no filling out this document. Are you clear on that?
Continued on next page. By Ms. Schrofa.
Ms. Chen, you could have called Crane Advisory and asked for your money back, right? Before filling out the document?
I'm not as smart as you.
Okay. Well, do you buy things in normal, everyday life?
Mr. Finkel said, objection.
The court said, all right. So we know she buys things in normal, everyday life.
You know you can ask or change your mind within a certain period of time, correct?
Let me make it clear. I sent the money to the bank account that's given to me by the people that I trusted.
Ms. Schrofa said, I move to strike, Your Honor. It's non-responsive to the question.
The court said, overruled. Overruled. Let her complete her answer.
So I sent the money to the bank account that was sent to me by the person that I trusted. In that situation, do you think I would call the company to call my money back? And do you think I would question about the document that was sent to me afterwards to complete?
Well, you worked 15 years at a bank, right?
Yes. So what?
So you know how to ask for a refund, right?
Mr. Finkel said, objection.
The court said, Ms. Schroff, I want you to be mindful of my order regarding the subject matter.
Ms. Schrofa said, let me move to 24T. Let's just put them up side by side, if we can. Did you fill out the document based on the form on the left side, or was it your husband?
So I'm sitting here and I feel like, are you trying to ask me am I tricked into signing this document? And if so, I think yes, I was tricked into signing this document.
That's your position, right? I understand that.
The court said, so Ms. Chun, listen to the question and then give an answer. As opposed to volunteering additional information that was not asked about. Go ahead.
Who signed that form for you? Was it you or your husband?
My husband signed it for me.
And were you there when he signed it?
This one, I did not.
And do you know how he sent the form in?
So in this situation, he told me he was contacted by MOS Farm. MOS Farm volunteered to complete a document because we sent the money to Crane Advisory. In order to complete this investment, he need to sign this document. He told me that, and he signed. I don't know what happened there.
Okay. So you don't know how your husband submitted this form. That was my original question.
He submitted it to the MOS Farm volunteer. That's who sent him this document.
Okay. And what did the farm volunteer do as the next step?
I don't know. Confirm receipt of the document?
So it's fair to say you do not know what happened between your husband and the Mountains of Spice Farm volunteer after the document was submitted. Correct?
I do not know what the MOS farm volunteer do after they received this document.
My question was, do you know what the farm volunteer said to your husband after he had submitted the document? That was my question.
So your question is asking, after my husband sent this document to MOS farm volunteer, do I know what the MOS farm volunteer responded to my husband? Is that your question?
Yes, ma'am. Actually, that is my question.
I think they confirm receipt of this document.
Okay. Now to actually have this document go through, your husband had to affirm the terms of the purchase. Correct?
I don't understand that.
You had to say, yes, this is what I want, correct?
I don't know. I don't understand what you're asking.
Did there come a time when your husband was in the process of activating the G Club's membership? Do you recall that?
I think what happened is, Miles said we were going to get a free G Club membership for the GTV additional shares we are purchasing. However, we never got the free G Club membership for the $210,000 we sent to the 2 accounts that were given to us. We only got maybe one of them activated, but not the other 4. So if that's what you're asking, that is what's happening, because the free G Club membership were not activated.
Ms. Schrofa said, I move to strike, Your Honor. And I repeat the question. To purchase.
The court said, overruled.
Let's look at DX 60676, shall we? Do you recognize that document?
Yes.
What is it?
This is a document that MOS Farm Volunteer told us to send to G Club to activate our free G Club membership account.
Okay, all right. You see it up there again?
Yes.
Ms. Schrofa said, okay. Your Honor, the defense moves DX 60676 into evidence.
Mr. Finkel said, could we see the next page, please?
The court said, any additional pages?
Mr. Finkel said, could I just have a moment with Ms. Schroff?
Counsel conferring.
Ms. Schrofa said, would you show the government?
Mr. Finkel said, Your Honor, objection. We might need to approach.
The court said, okay.
Continued on next page. At the sidebar.
Mr. Finkel said, this should be a minor issue. The only objection the government has to the document is that it has her husband's name on there. If the defense redacts that, that's what I pointed out to Ms. Schroff. It's her husband's email address. Do we want to redact it? And Ms. Schroff didn't really have a verbal response. In any event, if they can redact it, I'm sure they have the technology to do that. We have no objection.
Ms. Schrofa said, Your Honor, I don't think that the email name is mentioned. It's Living Social Fixer-Upper is the email address. They didn't.
Mr. Finkel said, that's...
Ms. Schrofa said, I'm not finished, please. We got this document this way from the government. The government redacted every email address before. I just want to be able to finish this thought. Because normally, the redaction would be, I don't know, if the email address is bobsmith@gmail.com. You would take out Bob, or you would take out Smith, or you take out Bob Smith, but you leave in at Gmail.com, so at least the jury knows that somebody was copied on it, so we can say you were copied on it. The government did not redact this Living Social Fixer-Upper email address. We had no reason to think that they would object to it now, and I don't see why we should have to redact it. But if you want me to redact it, 1, it doesn't belong to her. It belongs to her husband. 2, it doesn't matter. But it will take me a minute to do it.
The court said, so let's do the redaction.
Ms. Schrofa said, okay. Do you want to give us a 5-minute break?
The court said, isn't it possible for your helper to do that?
Ms. Schrofa said, my helper is having problems with the thing keeps popping off. The computer keeps dying, but...
Mr. Finkel said, do you want to go on to something else while he's doing the redactions?
Ms. Schrofa said, no, I really don't, but it will take us 2 minutes, Your Honor.
The court said, all right. So we'll have to take a very brief break.
Mr. Finkel said, thank you, Your Honor.
Continued on next page. In open court.
The court said, members of the jury, we're going to take a 5-minute break. I'm going to stick to the 5 minutes. Remember, don't discuss the case amongst yourselves. Don't permit others to discuss it in your presence. Don't read, watch, or listen to anything from any source that touches upon the subject matter of this trial. We will be back in 5 minutes.
Jury not present.
The court said, ma'am, you may step out. Don't discuss your testimony.
Witness not present. Recess.